immediately before the short adjournment, I'd taken you to that extract from Hansard.
You had.
And I said that my submission was that HMRC were, as it were, misusing that extract.
Yes.
If I could take you to paragraph 47 of their skeleton argument, which is in tab 2 of the core bundle, page 45, bottom of the page.
Yes.
So just to remind ourselves, back in paragraph 45, HMRC are saying that they're solving the problem identified by the upper tribunal about what the policy behind section 61.4 was, and what the upper tribunal had actually said was, why is it that this particular lessee is in the privileged position of having something deemed to belong to it, so it qualifies for allowances? What's special about these circumstances in 61.4? Well, in paragraph 47, HMRC say they adopt the description of the purpose given by the minister. Its purpose was to identify whether the lessor or the lessee bore the expenditure of providing the asset and to provide allowances to that person. Well, if one looks at what the minister says, he certainly says clause 43 reforms the rules, giving the allowances to the person, whether lessor or lessee, who actually incurs the expenditure. So, okay, if you incur the expenditure, you get allowances. But does that tell us what the upper tribunal was asking? But it certainly doesn't. It's not right to say, paragraph 47, its purpose was to identify whether the lessor or the lessee bore the expenditure. That's its purpose, if anything, was to give allowances to the person who incurred it. A different point. And then...
Well, I'm sure Mr. Gibbon and his team got what they believe was the most useful passage, but this is odd. This is actually primarily explaining an amendment on the floor of the House, and by way of introduction to the particular point which the amendment is addressing.
Yes, that's
a sentence or two about the...
Yes, a sentence or two.
But he says that he did actually explain the purpose of clause 43 more fully in committee.
Yes, we've looked at that. No one can find it.
I mean, they can find the report in the committee, but they can't find him explaining the purpose of clause 43.
Yes, that's right. Yeah. He didn't do it. He may have had the notes.
Perhaps you found the wrong passages.
Well, we've looked more than once. But
yes, yeah, right.
I mean, I think HMRC have looked as well. Yeah, we've got all the same thing. So he didn't do it, I'm afraid. But then, you see, if we go on to paragraph 48 of HMRC's skeleton, we get on the third line a reference to replacing an item, and then the third line from the bottom, let's see, on any replacements. So HMRC are now fixing on this, what the minister called the most common case is one of replacements. And then if you go to paragraph 63 of their skeleton, they carry it even further. The second line of 63, to recap, the statutory test was brought in order broadly to capture the situation where the lessee had to replace the item of plant and machinery. One asks, where do you get that from? It can only be from this extract from Hansard, where the minister is simply giving an example of the most common case. He's not saying why that's the purpose of this legislation at all. So that's my submission on a misuse of Hansard.
You're going into detailed points, are you?
I'm now going into basically dealing with this question of, did INSO incur expenditure on the provision?
Just before you do, can I ask a slightly different question?
Yes, do.
Which is about where section 61.4 would apply. Yeah. I mean, but for the existence of uh, 61.4b, I might have assumed that that was the prime situation. where you have a conventional lease of land or something, and the lease provides for the tenant to renew or whatever, and then it would make good sense for the tenant to be given an allowance in respect of expenditure he had incurred where the property was going to accrue to the landlord. But that's excluded. So what is the typical case?
Well, when you say it accrues for the benefit of the landlord, that is surely also the case with a chattel, in the sense that when the lease comes to an end, the lessor is now in a position to dispose of the chattel, to sell it.
I mean, even that's odd. If you take a lease, we assume a lease under which the tenant has to supply a particular chattel, but the chattel doesn't accrue to the land. Well, so we assume that the lease provides that the chattel has to be provided for the benefit of the landlord, such that the landlord gets title to it. I don't know.
Well,
what sort of item would that be?
I'm not sure it's to do with the item necessarily, but if I could give an example, which I would submit is not particularly unlikely. Suppose that this is a finance lease arrangement, and the lessor says, "Okay, I'm prepared to buy this and let you use it, but I want you to incur some of the costs. So we'll jointly purchase it, let's say."
Some of the purchase costs?
Yes.
Right.
So that on any view, that's the sort of expenditure which HMRC would accept is expenditure on provision. So the landlord says, "I'll pay 80%, I'll contribute 80%, you contribute 20%. And obviously the rental will be adjusted accordingly. And in those circumstances...
But the lessor has, the lessee has no ownership interest, despite that arrangement.
No, the arrangement is simply that he's going to lease it, but having contributed 20% of the cost, he's going to get a reduced rent accordingly, I suppose.
It's very hard to believe that I mean, whether or not that's... I know you say that the statute bites in that situation, but it's very hard to believe that that was what the draftsman primarily had in mind.
No, sorry, I wasn't suggesting that was what the draftsman primarily had in mind.
So what did he primarily have in mind?
Well, it may be she primarily had in mind your example of a fixture. But along comes the 1985 Act and carves out a special code, an exhaustive code for fixtures. But the draftsman nevertheless wants to preserve 61.4 for where it bites in a non-fixture situation. And what the upper tribunal was interested in was why. What's the particular circumstances where the lessee in that situation should be privileged? And I think I've taken you to what Mr. Gibbon relies on. That is not an answer. We don't have an answer either in terms of what's special or what did the draftsman have in mind particularly that made it a special case.
I did see, obviously, in the skeleton arguments, but I'm afraid I didn't attempt to work it through. Something about the history. Is this correct, therefore, that the original version of Section 61 didn't, or 61.4, didn't have B?
Yes. If you can see that. Sorry to interrupt. You can see that from the words after.
Yes. No. I can see
in
that.
relation to any lease entered into.
Yeah. So is this historically rather than logically a possibility that the 1985 Act introduced effectively B, or introduced provisions that made B necessary? Nobody really thought about what it would leave. It might leave almost nothing or completely nothing if, or only very unusual circumstances. But nobody troubled to work out exactly what those were. Is that?
I think that I would submit that's fair. I'd go a little bit further and say that there might have been something still left, and they wanted to preserve.
Without really focusing on what it was.
Yes.
Or maybe
to preserve the position, maybe in case.
So just working out what might be preserved, leaving aside your dual contribution type case.
Yeah.
We have to suppose a lease
which requires the tenant to provide a chattel which won't become part of the land, but title to which will nevertheless pass to the landlord.
Yeah.
It's quite hard to think when that would be. But
when you say provide the chattel, it's incurring it on the provision of, and I accept it is to provide, but subject to the width of the reference to provision.
I follow that, but there has, whatever the provide extends to, you have to provide machinery or plant. So there has to be some physical item that is provided by the tenant, which does not become part of the land, but title to which nevertheless passes to the landlord.
Yes. Could I just add one point, and maybe I'm just going back on the old point, not necessarily. There's no requirement that you and you alone make the provision, as it were. And whether that is a joint purchase or another instance of, in my example, the transport costs or the installation costs. So that maybe this is a slightly more obvious example where the landlord says, okay, I will buy and lease this to you, but I know nothing about installation. I don't want to have anything to do with it. You deal with that. Installing that plant, not so as to become a fixture, but installing it, making sure that it's where the tenant wants it to be. I don't want anything to do with that. I will pay the costs and you'll pay me a rent accordingly. Pay the purchase and you'll pay me a rent accordingly. But I don't want anything to do with that aspect of it. Now, is that, I would submit that's a possible, I'm not suggesting that was primarily in mind, but it's certainly not an unlikely situation that someone thinking about it might want to preserve.
But is it in fact that unlikely, just going back to more straightforward examples, to have a situation where what is leased is premises, but they include plant, which does not become a fixture. It could be, the nature of the trade could be such as it requires furnished premises, with office furniture or restaurant furniture. The kitchen stuff might become a fixture, but all the tables and chairs wouldn't. But they would nevertheless be part of what was leased and would belong to the lessor.
Can I just ask why they would? Why you're postulating that they would belong to the lessor? If it's, for example, a display case, that was an example that was given below by HMRC, where you've got a lease of a shop, and it's arranged between the lessor and the lessee that the lessee will pay for the purchase of a new display case for use in the shop by the lessee in his trade. It's not immediately obvious why that would belong to the lessor if it's not a fixture. Why the lessee simply, if he's using it in his trade, wouldn't simply be the owner of it.
Yes.
Well, but surely, I thought we were postulating. I may have lost myself in these examples, in which case, don't be embarrassed to say that you've got the right end of the stick.
Yeah.
I thought we were looking for examples where, at the end of the lease, the chattels, the plant chattels, which are not fixtures, revert to the lessor. Well, not revert; they've always belonged to the lessor, but they don't. Therefore, they don't become.
I accept that they always belong to the lessor, and all I was saying with respect was, I'm not sure that that example of the display case in the shop is an obvious case of something which always belongs to the lessor.
Well, but if the lease said I'm going to, if the lease said I'm going to lease you a fully furnished restaurant or a fully furnished office, and that will include the premises, plant and machinery in one sense, which is a fixture, but also tables and chairs and so on, which aren't fixtures. Okay. And that's all part of the lease. You get all of them.
I'm going to lease all those to you, but you've got to buy the tables and chairs, and then they belong to me. I'm suggesting that that's not necessarily the most obvious thing that the draftsman would have thought.
Anyway, there we are.
Yeah. I mean, we've all scratched our heads in the course of the various hearings as to what is a good example. HMRC did, as I say, give that display case one. It's not mentioned any longer. They've now talked about replacements, fixing on what the minister says. But in any event, I haven't been able to come up with something that is more obvious than any of that. my submission is really that obviously the draftsman in 1985 wanted to preserve the case of non-fixtures, and it's then the question of whether the language applies. The upper tribunal was troubled by that, in the sense that they wanted more guidance on the underlying policy to help them.
They weren't really troubled. They just said, we haven't got any of that guidance, and therefore we just go with the words.
Well, they did go on, in fact, later on in the decision to say we might have disagreed with Mr. Prosser on this point if we'd known more about the purpose, but since we don't, we agree with him that this is what it means. So they still were troubled throughout, it's fair to say, throughout the decision, throughout this part of the decision. But nevertheless, I would respectfully submit you're in the same position as they are in that sense. And the best guide to the purpose is the language used.
Yeah.
Well, so just to be clear, as it were, where we are, and in relation to the various issues which the upper tribunal was considering, if you go to paragraph 28 of the upper tribunal's decision in tab 7, they call something issue 2. Whether IMSO incurred the launch costs on the provision of plant for the purposes of section 61.4, that expression in 61.4. My submission is that expression has the same meaning throughout part 2, on the provision of, incurred on the provision of, that bears its ordinary meaning, and the ordinary meaning is to do with the function of the expenditure. So there has to be a relationship clearly between the expenditure and the plant on the provision of. What is that relationship? It's to do with function in my submission. It's to do with making it available for use as plant, for use in the trade. So that's, I'm going to take you to those authorities which I submit support that interpretation. HMRC say, well, no, it all depends who incurs the expenditure in relation to, for example, transport costs. It's got to be incurred by the person who buys it, because otherwise you don't satisfy the on the provision of. And that is focusing on who incurs it in my submission, rather than the function of the expenditure. And that's something specifically that in Benodico, Lord Wilberforce said is not the right approach. You don't focus on the person, you focus on the function of the expenditure. But the first case that I wanted to take you to is Berkeley Curl, which is at tab 32. Now that's in the other bundle of authorities.
That's the dry dock case.
I beg your pardon?
Dry dock case.
Yes. Now, if you look at the head note, you see that section 279 of the Income Tax Act is set out. Where a person carrying on a trade incurs capital expenditure on the provision of machinery or plant for the purposes of the trade, there should be made to him for the year an allowance, an initial allowance. So there's no concept of belonging. There's no requirement of belonging. There's no B. It's all to do with incurring expenditure on the provision of machinery or plant. In their skeleton argument, HMRC say, well, actually, in pointing that out, the upper tribunal was wrong. Let me just... This is paragraph 54 of HMRC's skeleton in tab 2. So HMRC quote the upper tribunal saying that what was said in Berkeley Curl was given in the context of statutory provisions that contain no belonging requirement. Then HMRC say, with respect, however, this is to misstate the effect of...
So, sorry, which paragraph?
Yeah, 54.
54, thank you. Yeah.
So it's the quote about, in the context of statutory provisions that contain no belonging requirement. With respect, that's to misstate the effect of the legislation under consideration, which both included a belonging requirement in the sense of having the result of belonging, albeit contained in a separate provision, cutting down the provision directly under consideration. Now, what HMRC seem to be saying is that There's some other provision which cuts down section 279. That is not correct. In relation to other allowances, not initial allowances, but annual allowances, there was a belonging requirement. But it was only in 1957 that the legislation was changed. So that may be what your point is. Sorry. So then I need to retract what I said. By 1965, which is when this case was being considered, there was a belonging requirement. That's right, and I apologise, I got that wrong. There was a belonging requirement in a different section, which is true, cut down section 279 so as to say that you only get allowances, including initial allowances, if the machinery or plant belongs to you. So I'm wrong, and Mr. Gibbon is right, that when the upper tribunal was saying there was no belonging requirement, that was incorrect. But I think the point is still valid, that section 279, which is what the House of Lords were focusing on, itself contained no belonging requirements. And they were simply looking at the words, expenditure incurred on the provision of machinery or plant. They weren't, as we'll see,
capital expenditure.
Capital expenditure.
And give me an example of one which wouldn't involve belonging. Capital expenditure.
Well, there's one in the 1990 Act, a case where someone is party to a contract under which they shall or may become the owner. Hire purchase is the particular example in section 60. A hire purchase contract where you incur rent, or you pay rent for the use of plant, and you've got an option to purchase. Part of that rent, the non-interest element of it, is treated as regarded as capital expenditure. That rent does not involve belonging, which is why section 60 says that the person who's incurring that capital expenditure is treated as the owner. The plant is treated as belonging to him. So there's another deemed belonging provision. It's expenditure which doesn't involve belonging, but which is deemed to satisfy the belonging requirement because it is incurred on the... This is the section immediately before our section 61, if you want to have a look at it. Back on page 95 in tab 9 of the earlier authorities bundle.
Well, if you want to, I
you asked me to give an example.
Yes, but I didn't. I just wanted an example in conceptual terms.
I see.
Case.
Well, here's one that is recognised by the legislation.
Yeah.
So if we go back to Berkeley Curl, I think the facts are very short. There was expenditure on the construction of a dry dock, and there were also transport installation costs incurred. And if I can take you to what Lord Reed said at page 680.
Sorry, just one moment. It doesn't say in the head note there were transport costs incurred, but you say there were.
Well,
I'm not being picky. I had the impression, but I haven't read this properly, and you're about to make us read it properly, that references to transport costs were, as it were, given by way of illustration in the speeches. That
I apologise, you may be right about that. That I'm sorry that Lord Reed and the other judges in the House of Lords.
Well, you'll show us
as an example. Yeah. Let me show you 680, Lord Reed. So Lord Reed sets out at between B and C section 279, which we've had a look at. And then he says, so the question is whether if the dock is plant, the cost of making room for it is expenditure on the provision of the plant for the purposes of the trade of the dock owner. In my view, this can include more than the cost of the plant itself, because plant cannot be said to have been provided for the purpose of the trade until it's installed. Until then, it's of no use for the purposes of the trade. This plant, the dock, could not even be made until the necessary excavating had been done. So it's making room for rather than transport costs. It's installation.
It's completely different. It's a complete. I mean, it seems to me a most extraordinary argument that the revenue are running. I don't see how, but maybe I don't see how digging the hole in which you're then going to put which you're then going to line and put in all the machinery is obviously part of it, isn't it?
Well, I would submit so, but we see in the next case as well that they're still resistant to any sort of widening of the scope of the concept of provision. So is the cost of the provision of plant can include more than the cost of the plant itself? I don't see how expenditure which must be incurred before the plant can be provided can be too remote. So one just stops there and applies that to launching satellites into orbit. My submission is that the point that Lord Reid is making is that if something has to be done and money has to be spent in order to get something to be able to be used as plant in your trade, that can be regarded as part of...
Maybe other passages help you more, but I mean, if this was all, given the context, I'm not sure it was really easily transferable to the case of launching a satellite.
Right. Well, he wasn't considering the launch of satellites, I accept. And then if we go to Lord Guest at page 686, just above F, the second point raised by the appellants, even if the concrete work were plant, the cost of excavation didn't qualify. The Commission has upheld the contention of the revenue on this point, their view being that the expenditure was too remote from the provision of the dry dock. In my view, they were wrong. The excavation was a necessary preliminary to the construction of the dry dock, and in my view was covered by the provision of plant. Provision must include something more than the actual supply. In this case, it includes the excavation of the hole in which the concrete is laid. And then Lord Donovan is to the same effect on page 691. He really adds nothing, but this is at H on page 691. The necessary excavation comes within the words expenditure on the provision of machinery or plant. So then if we go to tab 19, which is Ben Odeco.
Just pausing there. So can we take from this case that whatever provision means, whatever qualifying expenditure means, capital expenditure means, it means something more conceptually than just the purchase cost, but that there is a remoteness test. They're not saying there isn't a remoteness test. They're saying there is one, but we think that building a dry dock comes on one side of it. It's not too remote.
And Ben Odeco is an example of where the House of Lords said something was too remote.
Was or wasn't?
Sorry,
I misheard you, I'm sorry.
Was too remote.
Was too remote. So it illustrates the other side of the line.
Yes, although that was a case where it was the borrowing costs, the interest paid on borrowing to acquire, they said was too remote. So if I could just take you to that case, because there's a discussion more generally about what's the meaning of incurring or provision of in the House of Lords. Tab 19. So I think the facts are very straightforward. It was simply money spent on acquiring an oil rig. The money had been borrowed and therefore there was an interest cost. The question was whether the interest was expenditure incurred, and it was accepted, I think. There was a separate question as to whether it was capital expenditure.
Well, as I say, it doesn't strike to me like capital expenditure. There you are.
The head note, that sum was in accordance with correct accountancy principles charged to capital.
Well, there you are. I suppose I had a little line there.
So there the legislation is at 1099. Just, we'll see there we've got it as it stands now with A and B, and B is the belonging requirement. If we go back to Lord Wilberforce at 1097. If I can pick it up at 1097 below B. So he's referring to a case called Sherritt, where a Canadian court had held that commitment fees were part of the capital cost. And then picking it up between C and D, he says, in that case, interest and the commitment fees were capitalised until the mine or the refinery were operating and therefore charged against operating. Mr. Justice Kerr referred in detail to accountancy evidence, some of which supported such capitalisation, some of which didn't. Reference was made to Winster and Chancery Lane. And then beneath that, in the end, he found the question was fairly arguable, but he was disposed to think that interest during construction can be part of the capital cost of property within section 11(1)(a). Similarly, the commitment fees. The relevant statutory expression there was the capital cost to the taxpayer of property. This, he considered, could include certainly the price, probably legal costs, might well include the cost of moving the assets to the place of use, and his opinion would include the cost to him of borrowing the capital required. My lords, this judgment is an impressive one, perhaps more for the full statement of the arguments on either side than for the actual decision, which, as the learned judge himself said, was arguable. In considering whether it should be followed, and so in effect preferred to the judgment of Mr. Justice Brighton, I bear in mind it arose under a different statute, and one which not only uses a different expression, but whose policy as regards deduction seems to be more liberal than the UK statute. The expression capital cost to the taxpayer makes it easier to include within deductible expenditure costs which the particular taxpayer incurs, whereas the UK words more objectively focus on expenditure directly related to the plant. The one draws a line around the taxpayer and the plant, the other confines the limiting curve to the plant itself. As to policy, the Canadian Act allows deduction of the expenditure of issuing or selling shares, and so on. Then he notes to United States authorities that take a different view. Then he says, below B, an important principle is that taxpayers in objectively similar situations should receive tax treatment. And he makes the point that why should it be that someone who doesn't borrow but use their own funds is worse off than someone who borrows and gets an allowance. If I can pick it up just below E, the words expenditure on the provision of do not appear to me to be designed for this purpose. They focus attention on the plant and the expenditure on the plant, not limiting it necessarily to the bare purchase price, but including such items as transport and installation, in any event not extending to expenditure more remote in purpose. In the end, the issue remains whether it's correct to say that the interest and commitment fees were expenditure on the provision of money to be used on the provision of plant, but not expenditure on the provision of plant, and so not within the subsection. And he decides that that is the case.
Just probably showing my ignorance, it's the taxpayer who's arguing for the allowances here.
Yeah.
From which I infer that this was the best the taxpayer was going to get. So the taxpayer was not entitled to deduct the borrowing costs when calculating the profits of its trade.
Because they were capital, perhaps. I mean, there were strict rules in those days which, unlike the rules today, where any sorts of interest on a loan relation was deductible. Yeah.
And just going off at a tangent for a moment longer, in our case, suppose IMSO had been generally taxable,
yeah,
and it had incurred launch costs in circumstances where it couldn't get capital allowances, could it have deducted the cost from its profits?
No, the launch costs clearly are on capital account.
Yes, I see.
It's common ground that the launch costs were capital expenditure for the purposes of section 61(4).
I'm not seeking to go behind that. Just explain to me why.
Because they were a one-off expense that was necessary in order to get a capital asset as usable as plant. I mean, even though they didn't own the satellites, they were capital assets for the purposes of their trade. They weren't stock kind of thing. And this was a one-off expense which was necessary to get that turned into usable plant, and on that basis would be regarded as on capital account. But that's common ground.
Yeah, I'm sure.
So that's Lord Wilberforce. So just stopping there, he's saying that it's an objective test, first of all, back on 1097. And it's looking not at the taxpayer, but at the connection with the plant. In other words, I would submit it's a functional test. If you go to Lord Russell at page 1106,
is it a functional test? It's attention is focused on the plant and the expenditure on the plant, but it's to do with the plant, but it's a remoteness test, isn't it? It's how closely linked is it?
Yes, but the linkage in my submission is to do with, well, clearly in this case it was too remote.
Yeah.
But in my submission, the linkage in question is to do with what function the expenditure performs, and that's when.
Do you get that from anywhere? I mean, is that, am I missing something? It doesn't say that, does it? That's just what you infer, is it, from the passage, the passages that we've looked at?
Well, when at 1098E, Lord Wilberforce says, not limiting it necessarily to the bare purchase price, but including such items as transport and installation. One asks the question, well, what is it about transport and installation that means that they qualify and are not too remote? In my submission, it's the function that the expenditure on transport and installation are performing, which is to enable you to get the thing to the place you're going to use it or to install it. It's performing a function of enabling you to use the thing in your trade. That's the function of the transport.
Well, just you could have said that as well. It must be something a bit different or more than, because you could have said that about the financing costs as well. If it was a sort of but for, you know, you need to spend this to get the thing working.
Yes, but the reason he says that's too remote, not in terms of its function, but simply it's one step too far back.
Exactly, but it's something a bit different, isn't it? To my mind, it's not. It's something a bit different from function of the plant. It's to do with, I don't know, it's a sort of nexus or proximity test. It's a more factual test, isn't it? Of I don't know, just why you're spending the money or why you're incurring the particular ancillary cost of whatever sort it is.
Well, when you say why, it's not a subjective test, I would say.
Okay.
So, and that may be.
I'm just wondering whether part of the problem isn't you've come up with this phrase, a functional test. I suspect we all may mean slightly different things by it.
Right. Okay.
Do you need? Is it just a label, or is it a crucial part of your?
Well, it's intended to draw a distinction with what the revenues case is, which is where they say that if transport costs were incurred by the purchaser, that would be fine, but not if they're not. Now, in each case, I would submit, whether they're incurred by the purchaser or not, the costs are performing the same function. The fact that in one case they're incurred by the purchaser is focusing on the person who's incurring them, which Lord Wilberforce said you're not supposed to do, or the legislation is not doing that, unlike the Canadian legislation. It's not focusing on the person who's incurring them. And in my submission, so it's really, I hope, getting this from the examples that Lord Wilberforce is giving.
I think I'd understood HMRC to be saying, I may be corrected, I don't want to characterise their case before they've had the chance to put it before the court, that they were on the remoteness test as well. They were saying that launch costs of a satellite that you don't actually own is just too remote.
Right.
So
but what is it about ownership that means that that's the be-all and end-all? Why is it too remote if it performs the same function for IMSO as it does if it had owned it?
Because aren't we dancing around the daisies a bit? If it's remoteness, in the end it's a judgment about how far the particular expenditure is from the item in question. And there's no knockout blow. It's not that it's to do with personality or identity or ultimately what you're going to do with the thing. It's a sliding scale. There are shades of grey along the way. And
well, but HMRC aren't saying there's shades of grey. They're saying there's one key,
which is identity,
which is ownership.
And who?
Yes, who owns it?
Who rather than what?
Yes. So that isn't, I would submit, really about remoteness, because if it's incurred by the owner, it's not too remote. in its nature it's not too remote, why does it become too remote when it's incurred by somebody else? And my submission is that is muddling up the A requirement, expenditure on the provision of, with the B requirement, and in consequence it belongs to you. HMRC are merging those two and saying there's something about belonging lurking there in A, even though it's B that deals with belonging, not A. So that what they call the core expenditure, which is ownership, acquisition cost, they're saying is something that the person who incurs the transport cost also has to incur. My submission, that's just muddling up two separate requirements in the legislation. But perhaps it's a little bit clearer if one goes to Lord Russell then, on page 1106. And it's really below G, in my view. In my view, the question to be asked is...
Sorry, I've lost the page. Can you help me?
1106.
1106. Got it. Thank you.
Just below G. In my view, the question to be asked is, what is the effect of particular capital expenditure? Is it the provision of finance to the taxpayer, or is it the provision of plant to the taxpayer? In my opinion, the effect of the expenditure was the provision of finance, not the provision of plant. I would add that I don't seek to confine qualifying capital expenditure to the price paid to the supplier of the plant. I should have thought that, for example, if the cost of transport from the supplier to the place of user is directly borne by the taxpayer, it would be expenditure on the provision of plant for the purposes of the taxpayer's trade. There may be other examples of expenditure additional to the price paid to the supplier, which would qualify on similar grounds. Obviously, this is
left out the last. It's all obiter.
It's all obiter, of course. But in focusing on the effect of expenditure, maybe that's a better word than function. What does the expenditure do in connection with the provision of the plant? And if it enables the thing to be transported so you can use it, that I would submit is what Lord Russell is saying. So if I can then go back to what the upper tribunal said about all that particular point about the meaning of on the provision of, paragraph 74 of tab 7. So earlier on you see in the decision references to Ben Odico and Barclay Curl. And then at 74, the upper tribunal says, pausing there, if IMSA had been the owner rather than merely a lessee of the satellites, we don't consider there could be much doubt that the launch costs incurred would have been expenditure on the provision of the satellites, given the FTT's findings that the satellites were of no use whatsoever until they were launched into orbit. HMRC argued, however, that the fact that the satellites didn't belong to IMSO makes all the difference. In their submission, since IMSO did not incur the core expenditure of providing the asset, namely the cost of acquisition, the launch costs that it did pay were simply ancillary or freestanding expenditure. HMRC supported the FTT's conclusion that without ownership of the satellites, IMSO had simply paid to move someone else's plant from A to B, that this couldn't involve expenditure being incurred on the provision of the satellites. In effect, that argument involves an assertion that IMSO's status as a person who didn't own the satellites converted expenditure that would have incurred by an owner had been on the provision of the satellites into expenditure that wasn't on provision. That involves a focus on IMSO rather than on the nature of the expenditure, contrary to Lord Wilberforce's approach in Ben Odico. In his oral submissions, Mr. Gibbon rightly noted that the word provision should not be read in isolation, as section 61.4 is concerned with whether expenditure is incurred on the provision for the purposes of the trade of machinery or plant. He argued that the focus should accordingly be on the specific plant and machinery. However, we don't consider this wider context alters the conclusion we've expressed at 76 above. Lord Russell in Ben Odico held that the focus should be on the effect of particular expenditure and not on the particular attributes or circumstances of the person incurring the expenditure. If the launch costs would have had the necessary effect if incurred by an owner of the satellites, we see no reason why, in the context of authorities on statutory predecessor to section 24, it should be deprived of that effect when incurred by someone other than an owner. And then at 78, Mr. Gibbon also argued that in order to amount to expenditure on the provision of plant and machinery, there must be some sort of nexus between the incurring of the expenditure and the plant and machinery belonging to that person. We don't, however, consider that approach to be supported by authorities. The decision of the House of Lords in Berkeley Court was given in the context, and this is where I see now they went wrong. We don't consider that the House of Lords had any concept of belonging in mind when they determined that expenditure on the provision of plant and machinery was expenditure on the provision, and the installation of plant and machinery was expenditure on the provision of that plant and machinery. Therefore, our interpretation of the authorities is that the launch costs would involve expenditure on the provision of the satellites. We acknowledge that under the 1990 regime, with its belonging requirement, a person who incurred what HMRC referred to as freestanding expenditure on the costs of transporting plant and machinery, which he doesn't own, would not be entitled to capital allowances under Section 24. However, this is because such a person wouldn't be able to satisfy the requirements of B, rather than because the expenditure is not on the provision of the plant and machinery. That difficulty doesn't trouble Inmarsat in this case, because as Mr. Prosser observed, if Section 64.14 applies, then the satellites would be deemed to belong to IMSO. Now, I respectfully support the analysis of the upper tribunal there in rejecting HMRC's arguments. But then we come to HMRC's separate argument, which is to do with multiple ownership, because HMRC said next, if it's right that the expenditure incurred by IMSO, these launch costs, come within Section 61.4, so that the satellites are deemed to belong to IMSO, then that would have the result, which Parliament can't have intended, of denying allowances to the lessors for their own purchase costs. Because if the satellites belong to IMSO, they can't also belong to the lessors. Now, my response to that submission is the point I made earlier on this morning, to do with being careful to examine the purposes of a deeming provision. So that the purpose of this deemed belonging in Section 61.4 is to enable the lessee to qualify for allowances. It's not to prevent the lessor from qualifying for allowances for the lessor's own expenditure.
Sorry, can you say that last bit again? The purpose of the deemed belonging is to enable the lessee to qualify for allowances. It's not to...
in respect of his own expenditure.
Yeah.
Not to prevent the lessor from qualifying for allowances.
In respect of his own expenditure.
In respect of his own expenditure.
So you sort of take your own expenditure with you.
You take your expenditure with you in accordance with the deeming. And you'll see that 61.4 doesn't say shall belong to the lessee and not to the lessor. By contrast, Section 60 does. Section 60, which is about the hire purchase case. So we're still in tab 9. Page 95 in tab 9. (61A). The machinery or plant shall be treated for the purposes of this part as belonging to him and not to any other person. So when Parliament wants to say it's to one person and only to one person, it says so. And if one asks why Parliament said it there, the answer is, well, clearly the reason why Parliament said the hire purchase plant is deemed to belong to the lessee is because the lessee, from an economic point of view, is buying the plant from the lessor, so that you don't want it to belong to the lessor at all. You want it to belong to the lessee, the buyer, not the lessor, the economic seller. There's no similar policy behind saying it shouldn't belong to the lessor if the lessor has incurred expenditure as well. There there are other provisions in the 1990 Act which say that something belongs to one person and not to anybody else. In the Fixtures Code, there's an exhaustive code dealing with fixtures, and the legislation says expressly, if under this code, plant belongs to one person, it doesn't belong to anybody else. Well, one can see again, if you're going to have an exhaustive code, that makes sense. But 61.4 does not purport to be an exhaustive code dealing with both the lessor and the lessee. And nor would one expect it. If I can give this example, if the lessee, instead of incurring transport costs or launch costs, joins with the lessor in buying the plant, I mentioned that example before, and you weren't terribly impressed with it because it's not necessarily a very likely scenario, but in any event, if the lessee joins with the lessor in buying the plant, which is going to belong to the lessor and will be leased, that clearly falls within section 61.4. On any view, it's core expenditure, as HMRC would put it, its purchase cost, and it results in belonging, albeit by somebody else. It would be absurd in that case if the consequence of the lessee, say, incurring 20% of the costs, meant that the lessor didn't get allowances on their 80% of the costs. Clearly, Parliament can't have intended, by deeming it to belong to the lessee, that it shouldn't belong to the lessor at the same time for their respective purposes of getting allowances on their respective expenditure. And the 19...
Remarkable that any apportionment system of this sort simply shouldn't have been provided for at all by the statute and made to be made up by the courts.
Apportionment?
Well, that's what you're talking about, isn't it?
Well, clearly not in my example. In our facts, we know how much IMSO has incurred by way of launch costs. In my example I just gave now, where the lessee incurs 20%, we know how much they've spent. There's no question of apportionment at that stage. There's nothing to apportion at that stage. There is a difficulty, which I'll come on to, and this may be what you've got in mind. But I'd like, first of all, to give
I think you keep going.
To give an example of where the legislation clearly expressly recognises multiple ownership. In fact, I've taken you there already. Section 154. Do you remember the contribution provisions? And it says there, Section 154.2 says, the plant shall be treated as belonging to the contributor for so long as it belongs or is treated as belonging to the recipient of the contribution. So that's a case where, let's say, 100 is incurred on a plant, but 20 of it is contributed by somebody else, the contributor. The recipient, who's incurred 80, gets allowances on 80, but the legislation wants to give allowances to the contributor and does so by deeming it to belong to the contributor for so long as it belongs to the recipient. Now, in that case, the legislation expressly recognises it wants to give allowances to both of them, and it recognises that you can have multiple ownership. It treats there as being multiple ownership by the contributor for the purposes of him getting allowances on his 20.
Just remind me which section this was.
Yeah. It's in tab 10, section 154, which is on page 120 at the bottom of the page. It's really the words at the very bottom below subsection 2. The purpose of any allowance under part 2, that asset should be treated as belonging to the person making the contribution, with respect to which the allowance is given, at any time when it belongs or is treated under part 2 as belonging to the recipient of the contribution. So the legislation recognises, it deems there to be multiple ownership. It's got no problem with that because, as I've submitted, the deeming is for their particular, each for the particular purposes of allowing persons to get allowances on their own expenditure. It shouldn't be regarded as sort of creating conceptual problems once one recognises the purpose and therefore the limits of the deeming. And just in case HMRC say, well, that's one exception, That's the only exception you've been able to come up with. There is another one. Section 40, subsection 5, back in tab 9. For the purposes of 4 above, and 4 above is the definition of the requisite period, which has certain consequences. Machinery or plant shall be treated as continuing to belong to the person who incurred the expenditure, so long as it belongs to a person who's connected with him, or a person who acquired it from him, and so on. So there again, we've got deemed belonging by someone, while recognising a belonging by somebody else. It's for particular purposes, clearly for the purposes of subsection 4, but all of these deemings are for particular purposes. Now, when my Lord Justice Underhill said, what about apportionment? The question is, if we go back to the section 154 example, where you've got someone contributing some of the expenditure, and someone receiving that contribution and actually doing the incurring on the provision. So they've both spent some money, as it were. And let's just look at the figures. Suppose the plant in question was bought for 100, but 50 of it was contributed by the contributor. So both of them get allowances on 50, and that makes sense. Suppose that the plant depreciates in value and is now worth 50. And then there's some event, let's say a permanent discontinuance of both the trades, of the contributor and the recipient. Both of them have to bring in a disposal value on that, in that case, which on the face of it is 50. Because it's a market value disposal. The market value of the plant is 50. So each of them brings in a 50 disposal value, despite the fact that the plant has depreciated in value by 50%. Normally, if plant depreciates in value, you don't get denied the allowances you've already received for the amount of the depreciation, because what's restricted or clawed back is any allowances in excess of the current value. But you don't get clawed back all of your allowances when the asset has depreciated in value. That would defeat the point of allowances effectively, which is to give you relief for the depreciation in value. So the question is, well, is that how it works, nevertheless? That they must both bring in, the legislation says market value, and they both bring in 50. If that's how it works, that's how it works. But there is an alternative way of looking at it, and it's not vital to my case. It's simply that we considered that the alternative way seemed to be the more sensible one, which is, and it doesn't help us at all, we're actually worse off by this argument, because if section 78(1) applies, and Inmarsat is treated as incurring capital expenditure equal to market value, that market value may well be a great deal more than the amount that IMSO spent on the launch costs. And if that's the way it is, we're very happy about that, because we get much more allowance than the amount of the expenditure IMSO incurred. My submission is simply that that would be a very odd result, and it would also be an odd result if in the 154 example, the contributor and the recipient had all their allowances clawed back, where the asset had depreciated.
Unless I missed it, you haven't actually said what the alternative approach is.
Sorry. I apologise. The alternative view is to say, if they're each treated as the owner, then one must, for these purposes, regard them as co-owners. And if they're co-owners, then one could say they're co-owners in proportion to the expenditure that they've incurred, such that when you get to the disposal event and the market value, it's a proportion of the market value.
So they each bring in 25, not 50?
Yes. Now, that I would submit is a perfectly sensible way of avoiding that very anomalous, that odd result. And that's simply what we've suggested as what applies in relation to Inmarsat, that it's not claiming allowances on the full market value, it's claiming allowances on a proportion of the market value, what in Mr. Gibbons' skeleton he calls X%. Now, the FTT, this case didn't come by way of an appeal against a closure notice or an assessment. It was a reference by the FTT.
To the FTT.
To the FTT, but agreed between the parties, I'm sorry. But what the FTT decided in relation to that reference was to put over to another day, if necessary, all questions relating to the market value of the satellites. Now, that could include, I would submit, all questions relating to market value. This issue around whether it's a proportion of or the full amount. And if that's right, then you don't have to determine this question. All you would have to decide is, in principle, is section 78.1 engaged, and not bother about this apportionment or proportion X% issue at all. And if you're happy to do that, I'm very happy to do that. And if I win, then we'll have to discuss it at that time. If I lose, then it never gets discussed. But the important point is, HMRC say that this somehow undermines Inmarsat's argument about section 78.1 or section 61.4. It doesn't, because it's an issue which arises, as I've tried to explain with section 154, in any event. Whenever you've got two persons who are contributing to expenditure, and the legislation deems it, the plant, to belong to both of them, this issue arises.
So it's the co-ownership issue. You say we should decide that as a point of principle, whether you can have two entities as co-belonging, whether the plant can belong to two or more, presumably, at the same time.
Yes, as
in proportion
154
to their
says.
Capital
154 says it's treated as belonging to the contributor, so long as it belongs or is treated as belonging to the recipient. So that's recognising that
154 says that, but you want us to draw the conclusion when we come to section 61 that that's how it operates, and then leave all questions of quantum and the outworking for another day.
I'm very happy with that. Obviously, if you're not happy...
I thought you were suggesting something. You were suggesting that we didn't even need to decide the point of principle.
Well, what you do need to
decide... We
decide...
were leaving that up to us.
What I would submit you do need to decide is whether section 61.4 can apply to a case of a lessee who incurs some, but not all of the costs, the lessor incurring some of the costs. Can it apply in those circumstances, or do you say, well, no, it can't apply because that would deprive the lessor of allowances? That's all you have to decide.
That's right. So you were saying we could then go on and say what happens in the situation you put to us, and are they to be treated as deemed co-owners and therefore only responsible for 25 each?
Yeah.
Well, we don't have to decide that. You're happy for us to decide if we feel it's a necessary part of our reasoning, or to put it off to be decided on another day if it arises.
Yes, and that's what the upper tribunal did as well.
Yeah. Can I just sort of think around it for a moment? You're postulating a case where an asset that is leased has been funded by two people. Aside from the leasing position, you would be into section 153, 154, 155.
Actually, yes. If we hadn't, no, when you say aside from the leasing, if we'd done the leasing, but IMSO had contributed to the costs, in other words, said, you, the lessor, buy it and enter into the contracts for launch, we, IMSO, will reimburse your launch costs. If that's what had happened, Inmarsat would be entitled to allowances under 155.
I follow. Just sort of talk, leave our case out of it for a moment. Aside from the situation where you have two people contributing to the cost of an asset that is leased, if you have two people contributing, you're into the 153, 154, 155 code.
Yeah.
So what we are directly concerned with is a rather unusual situation where you have two people contributing to the cost of an asset that is leased. And more than that, we're concerned with a situation where you can't identify some specific item within the leased whole.
That each is doing 100% of?
Yes.
No, quite.
So going back to the origins, if you say the tenant had spent money on a lift or something, there'd have been no difficulty because the lift would be deemed to
one can sort of complicate it slightly and say, what if it's one item of plant which is made up of two things, and one of them says, I will spend it on that if you spend it on that. It's one item of plant. It may be that an answer to that is the legislation goes on to say that references to machinery or plant include parts of. Perhaps I ought to give you the section. This is in tab 10. Section 1617 on page 124. Any reference to any machinery plant should be construed as including a reference to a part of any machinery or plant.
Sorry, can you give me the section number again, please?
1617 on page 124. And I think it's section 83, back in tab 9, subsection 4. 83.4. The provisions of this part shall apply in relation to a share in machinery or plant, as they apply in relation to a part of machinery or plant.
Where are you reading from that?
That's 83.4, back in tab 9. The last page of tab 9. So that's where I get my co-ownership from, as it were, that if plant includes a share in plant, maybe what one has to say is that in these cases of multiple ownership, they own it in shares. That doesn't stop them getting allowances, because a share is deemed to include, or plant is deemed to include a share. But to go back to your question, it's true that one can't think of many cases of where there is a sharing of costs, where they're sharing the costs of a single item.
Yeah.
But certainly my example of co-purchase is one. You may say that's not very likely, but it's one which on any view falls within 61.4. There's absolutely no reason why, if the lessee joins in the purchase contract with the lessor, leave aside the likelihood of it happening. But in terms of the terms of the provision itself, if the lessee joins in the purchase contract and pays X% of the price, on any view he's incurred expenditure on the provision. And that must bring with it the operation of 61.4, but without prejudice to the lessor's own expenditure and own actual belonging. There's absolutely no risk of double allowances arising from any of this multiple ownership, clearly. And if one goes to what the upper tribunal said at this point, paragraph 80 onwards.
Now the last group of sections you read us 5 paragraphs all through. I think if we're going to do that again, I think just tell us which paragraphs and we'll read them to ourselves.
Yes.
But perhaps it
so it's paragraphs 80 to 85, if I could ask you to read those to yourselves. So I respectfully adopt those points as my submissions. Then if we go to issue 3A, as described at paragraph 86 of the Upper Tribunal's decision. In relation to the I3 satellites, whether IMSO was required under the terms of the relevant leases to procure the launch of the satellites, HMRC don't challenge the conclusion there was such a requirement in relation to the I2 satellites. Secondly, whether any requirement to procure the launch of the satellites was sufficient to amount to a requirement to provide the satellites. As regards the second of those, if I've understood HMRC's argument correctly, it's really a repetition of their point that launch costs do not amount to provision. So it doesn't add anything to what the Upper Tribunal call issue 2. So the real focus here is on this first distinct question, whether IMSO was required under the terms of the leases to procure the launch of the satellites. And if I can make my submissions on that point, there are 3 ways in which in our skeleton we put this, but my primary focus is on the way that the Upper Tribunal, the one that the Upper Tribunal dealt with and agreed with. It decided that the other 2 ways it didn't have to consider because we'd won on the first way. And I'm going to focus on that first way, if I may. So this relies on a provision of the master leasing agreement between the lessor, which was Abbey National Leasing, and IMSO, the lessee. That agreement is at tab 13 of the supplementary bundle. If I could take you to that. So that starts at page 191, that's the heading. It's dated the 20th of December 1991. Now, on the same day that that agreement was entered into, IMSO and the lessor, Abbey National Leasing, also entered into a novation agreement at tab 11 with the manufacturer of these I3 satellites. And under that novation agreement, the lessor, Abbey National Leasing, took over from IMSO as the purchaser of the satellites.
Sorry, that was tab...
That was tab 11.
Tab 11.
Took over as the purchaser pursuant to the original purchase agreement at tab 10. And the only reason I'm mentioning this is because in tab 10, at page 131A, is Article 21A of the original purchase contract, which said the contractor understands that...
So which page are we on?
Yeah, page 131A. I hope you've got an updated bundle.
Yes, we have.
Article 21A in the middle of the page. The contractor understands that Inmarsat intends to procure launch services for the spacecraft in reliance on the delivery schedule specified in Article 4. Just stopping there. So that was knowledge on the part of the contractor, that was General Electric, who were making the satellites, and which the lessor became aware of when it took over, novated the position as purchaser under that contract, took over from IMSO. And it was found as a fact, or at least the FTT accepted the evidence of the witnesses. In fact, they weren't required to be called to give oral evidence by HMRC. One of those witnesses explained in his witness statement that the lessor played no part in the launching of these satellites. It was IMSO alone that did so and was expected to. And as we'll see, it did so. So that was the sort of factual background to the entry into of this master leasing agreement, that it was always IMSO that was expected to do the launching, nothing to do with the lessor. So tab 13, if I can go directly to clause 703, which is on page 205. This is the clause that we rely on for saying that IMSO was required under the terms of this lease to procure the launch of the satellites, and it's headed compliance with law. The lessee shall have them attain all permits and shall satisfy the requirements of all pertinent laws. And then if we go back to see what the definition of pertinent laws is, that's on page 196. Pertinent laws means applicable laws, I'll come back to that, together with all other rules, directives and regulations and so on, affecting the leased equipment or the lessor in relation thereto, or the lessee in any pertinent jurisdiction, including the ownership, delivery, use, possession, operation, launch or disposal of the leased equipment. So stopping there, pertinent laws means applicable laws affecting the leased equipment or the lessor in relation thereto, or the lessee, including the launch of the leased equipment. So what does applicable laws mean? Applicable laws is defined on page 194 at the top. Means the convention of the international Inmarsat convention. Includes that in any event. I'll come to that convention in a moment. But before I do that, we need to see what this lease actually provides in terms of leasing. This lease agreement provides in terms of leasing. First of all, clause 2 on page 199. The lessor agrees to lease to the lessee hereunder, and the lessee agrees to take on lease from the lessor hereunder each spacecraft and the ancillary equipment in each case for the lease period applicable thereto. The lease period is defined on page 195, the period commencing on the delivery date and expiring at the end of the rental period applicable to such spacecraft. Well, the rental period is defined on 197, and it's basically 13 years.
Sorry, I wasn't keeping up. Yes, I see.
But in terms of what the delivery date is, the delivery date is defined on page 194. It means in relation to a spacecraft, the date on which delivery occurs, and then delivery is defined immediately above that. The point in time when title to such spacecraft and risk of loss passes to the lessor in accordance with the novated purchase contract, bracket such time being intentional ignition of the first stage engine of the launch vehicle for that spacecraft. So that this lease, the lease period, begins when launch begins, and it's at that point that the lessor title to the spacecraft passes to the lessor, and risk as well. And this launch is something which the lessor is having nothing to do with, and therefore the question is, well, is nothing going to happen kind of thing, or is there a requirement on the part of IMSO to achieve that and to get the lease period beginning? And our submission is that it's the compliance with laws, the pertinent laws, the applicable laws, the requirement to satisfy, the obligation to satisfy the requirements of the convention that achieves that. And if one goes,
just before you go to that, can I get the bigger picture a moment? Yep. Abbey National has contracted through the novation to buy the satellites. You point out that the rental period doesn't begin until the satellites are launched.
The lease period.
The lease period doesn't begin until the satellites are launched. If the satellites are never launched, what is Abbey National's position? I mean, I can't believe they left themselves terribly exposed, having to buy the satellites, but...
well, they didn't have to buy them because title only title only passes with launch.
So until launch, IMSO owns the satellites once they're finished?
No, I don't think IMSO ever owned the satellites as a result of the novation contract.
So General Electric are building the satellites. They want certainty someone's going to buy them, presumably.
Well, they've certainly got an agreement on the part of the lessor to pay for them.
So
only on launch.
I think there are stage payments along the way.
So from the General Electric's point of view, they're building the satellites. Abbey National has to pay for them by stage payments. And they had to do that regardless of launch.
Yes, those payments have to be made regardless of launch.
So Abbey National is on the hook for all those payments, whether or not launch happens. They must have had some recourse against
yes,
IMSO.
They did. There are provisions of the lease which require IMSO to make payments, irrespective of whether there is a launch.
And where are they, please?
I'm not sure we've got those because neither of us.
No. All right. So it's accepted that Abbey National had to pay for the satellites regardless of launch, and that if there was no launch, IMSO still had to pay Abbey National. So why should the lease require IMSO to procure the launch? Because Abbey National is protected anyway.
I'm not sure that maybe we need to look at this overnight. I'm not sure that it's fully protected because clearly in order for the lessors to get allowances, capital allowances, they need to it needs to belong to them. So that it's clearly in their interests that the belonging requirement is satisfied, that title passes, which is contingent on ignition and launch.
But now I'm getting confused again.
Right.
General Electric is building the satellites. Abbey National has to pay for the satellites regardless of launch. Surely it's going to get title regardless of launch.
But that's not what this says. This says that title only passes under the purchase contract, the novated purchase contract, to the lessor and risk as well, with the first stage of ignition.
Well, we're looking at the lease agreement.
Yes,
for this purpose, we need to look at the purchase agreement,
well,
don't we?
It recites perfectly accurately.
It
recites perfectly accurately in the lease agreement what the position is under the novated purchase contract.
So who's going to own these satellites? So General Electric's been paid for them. There's been no launch. Does General Electric own them?
I think the position is that title simply doesn't pass from General Electric unless there's launch. I mean, I think the underlying assumption is that there was going to be launch, and that this wasn't going to create any difficulty. So that's the working assumption I would submit is that there's going to be a launch. Title will pass, the lease period will begin. But
I quite follow that. It's just be very remarkable if those advising Abbey National hadn't ensured that they were safe regardless.
I'm not suggesting they weren't safe regardless.
No.
Because I think the right answer is that IMSO there are payment mechanisms in the lease which mean that IMSO has to
pay more.
Pay more to compensate the lessor. And at the very least to make good in one way or another the contributions to the payments of the purchase price that the lessor has made.
But on that basis, in terms of the contract between Abbey National and IMSO, there's no reason for Abbey National to include a requirement for IMSO to launch.
the upper tribunal mentioned that it was the FTT had found in relation to the I2 satellites that there was a requirement to launch, because the I2 satellite, broadly the same form agreement, said in terms that IMSO shall procure the launch. One might say the same about that. Why say that? One answer given by the upper tribunal was that all of these satellites were necessary in order for IMSO to be able to carry on its trade. All 6 of the satellites were creating an overall system which enabled the telecommunications trade to be carried on. We'll see in a moment. That enabled IMSO to charge at economic rates people who were using the satellites for their own purposes, making use of what the satellites were doing for their own purposes. So IMSO was going to carry on a trade, expected to be profitable trade of its own. The only way it could do that would be getting all 6 of them launched into space and operating. So that's how IMSO would have the funds to pay the rent and whatever other payments it had to make. So what the upper tribunal said, correctly in my submission, it was that the interests of the lessors, that IMSO, that the launch should take place such that everything should work as was expected to work. Allowances would be available to the lessors. IMSO would have the wherewithal to pay the rents and so on and so forth. That was what the whole leasing arrangement was based upon. And therefore, it would be wrong, I think the upper tribunal concluded, to assume that the lessor was completely neutral about any of that happening.
Yes, I see.
In any event, what the agreement does say is that IMSO shall satisfy the requirements of the convention. And then I want to take you to the convention, which is at tab 6 of the supplemental bundle.
Tab 6s, but anyway.
Yeah.
Yeah, behind tab 20. It's page 25.
Yes, thank you. So this is the convention. I don't need to read the opening words, or for the moment the definitions in Article 1. So Article 2 establishes IMSO as the organisation. Article 3 says the purpose of the organisation is to make provision for the space segment necessary for improving maritime communications and so on. And I think this was amended. If you look at page 38b, this is the updated version. It talks about other things that the space segment would be necessary for improving. But I don't think one needs to bother too much about those amendments. They don't alter the basic thrust of the convention as it stood originally. So Article 3 is the purpose. The organisation shall seek to serve all areas where there's need for maritime communications and so on. Then, before we leave Article 3, make provision for the space segment necessary and so on. I mentioned earlier on, the evidence was that all 6 satellites were necessary for creating that space segment. They were all required for full global coverage. And then Article 5 over the page, 5.3, the organisation shall operate on a sound economic and financial basis, having regard to accepted commercial principles. 6, the organisation may own or lease the space segment. And then I can jump to 9, which is the organs of the organisation, including the council. And then jump again to 15, the functions of the council on page 32. the Council shall have the responsibility, having due regard for the views and recommendations of the Assembly, to make provision for the space sector necessary and so on for carrying out the purposes of the organisation in the most economic, effective and efficient manner consistent with this convention. And to discharge this responsibility, the Council shall have power to perform all appropriate functions. And then, so 15A includes acquisition by purchase or lease, operation, maintenance, utilisation of the Inmarsat space segment, and that's defined back in Article 1 as the space segment owned or leased by Inmarsat. And then G, adoption of financial policies, charges for use of the Inmarsat space segment. So the whole idea is it's going to be carrying on a trade and charge for what it's doing.
You're writing very small on this. Is any of this in dispute? What's it supposed to be getting? Where's it all going?
Where it's all going is I'm trying to make the point that the requirements of the convention, in circumstances where if one looked at the moment or a day before the due launch of each of these satellites, the requirements of the convention were to go ahead with the launch. And it would not have, and this is what the upper tribunal accepted, that if you looked at the years before, it could be that so might say, well, actually, we're not going to go ahead with this launch. We've entered into the launch contract, but so I need to set the scene a little bit more. But
okay.
So there's the combination of also Article 19, establishment of utilisation charges. So it's a combination of what the purpose of IMSO was, to create the space segment, and the requirement to do it in a way that makes financial and economic sense.
I mean, to be more specific, the lease obligation is an obligation to satisfy the requirements of pertinent laws, and you've explained that the pertinent laws include the convention.
Yeah.
But if it's an obligation to satisfy obligations in the convention, you've got to look for an obligation.
It doesn't say obligation.
If, for example, one looks at Article 15, that's about functions and powers.
Yep.
I can't see how that creates an obligation. So the ones that might be thought to create an obligation are presumably 3.2 and 5.3. Is there anything else that creates an obligation?
No. Okay, 3.2 and 5.3. But the only reason for going to 15 and 19 is to see that when you look at 5.3 and operating on a sound economic and financial basis, that's in the context of the intention to charge people for using the communications service, which you can only obviously do when these satellites are up in orbit. So that's it on the convention. But then we see that following entry into the master leasing agreement, IMSO enters into launch contracts for the launch of the particular I3 satellites. I don't need to take you to those, but they are at tabs 15 and 16. There's one for one of them and another for two of them. So that covers all three of the satellites. That happened in 92 and 93. So we've got 91 is the leasing agreement, 92 and 93 is the launch contract. And then in 1996 we get the actual launch. So in circumstances where these I3 satellites are necessary, they need to be launched to create the space segment. The question is, how did the convention apply to IMSO? What requirements did the convention impose on IMSO after those launch contracts have been entered into and before the launch itself? So my submission is one doesn't look at the leasing agreement on the day it was entered into and say what are the requirements. They're ongoing requirements. And after the launch contracts have been entered into, subject obviously to something happening where it would make sense, including in financial terms, for IMSO to say, I'm going to abort this launch. My submission is, having entered into these launch contracts, the convention required IMSO to achieve its purpose and to operate in a sensible financial way to carry on with the launch and not to abort the launch. And that, therefore, is the effect of the requirements of the convention.
Yeah.
And that obviously isn't an obligation of the convention. They're requirements of the convention. But all that the master leasing agreement requires lays down is an obligation to satisfy the requirements of the convention. The FTT had rejected that argument on the basis that it was a generalised obligation. Well, it's true it's a generalised obligation, but my submission is it's none the worse for that. If, on proper analysis, that generalised obligation did require IMSO, in accordance with its raison d'etre and so on, to procure the launch of the satellites, then that's good enough.
Yeah.
The upper tribunal disagreed with the FTT. Perhaps I could pick up at paragraph 89 of the upper tribunal's decision.
How much do you want us to read?
Well, could I ask you please to read to paragraph 94? And in relation to the point at paragraph 93.2, do you see where, fifth line from the bottom of that subparagraph, the upper tribunal says, however, the I3 satellites were ultimately launched, so a point must have come at which it would have made no commercial sense for IMSO to decide not to launch. HMRC say, well, that's ex post facto. It's only looking at afterwards to see that it was launched. But in my submission, that isn't a good point, because the real point is that there was no time at which, shortly before the launch, or any time up to before the launch, when it would have made financial sense to abort the launch. That's really what the upper tribunal is saying. It's not focusing on ex post facto reasoning. And in relation to 93.3, HMRC, I think, still say, well, look, if you're under an obligation imposed by the convention, that can't be an obligation for the purposes of Section 61.4. But of course, there are obligations owed to different people. I can promise Lord Justice Underhill that I'll be as quick as I can, but that doesn't create an obligation towards Lord Justice Newey, although obviously it does, or for the usher, perhaps. The relevant question under 61.4 is there an obligation to the lessor imposed by the terms of the lease, not whether you're already required to do something vis-a-vis somebody else. Well, I won't pursue my alternative ways of getting to that result. I'll focus on the one that the upper tribunal agreed with, if I may. So then I can come to what the upper tribunal called issue 3b, which, if we go back to paragraph 80, if it goes to paragraph 99, it's to do with the reference to a lessee incurring capital expenditure in 61.4. So if I take you back to tab 9 of the authorities bundle and section 61.4, so when 61.4 says a lessee incurs capital expenditure, the question is whether that imposes a sort of timing requirement, that at the time the capital expenditure is incurred, the person has to be a lessee. Now, just to recap in terms of the facts, the leasing agreement was entered into in 1991. After that, the launch contracts were entered into and expenditure was incurred. And after that, the launches occurred in 96, and the leasing agreement became an operating lease, as it were, at that point. So it's true to say that at the time when the expenditure was incurred, there was a leasing agreement in place, but the lease period had not yet begun. The term of the lease had not yet begun. And is that fatal to IMSO being a lessee who incurs capital expenditure? Now we need to read subsection 8 of 61.4, I'm sorry. (61.8) says, in this section, lease includes an agreement for a lease where the term to be covered by the lease has begun, and only tenancy, but doesn't include a mortgage, and lessee and other cognate expressions shall be construed accordingly. And what HMRC say is, well, yes, lease only includes an agreement for lease, but if and when the term to be covered by the lease has begun. So that if you've simply got an agreement for lease, and the person who's to be the lessee, if I can call them the lessee nevertheless, the person who's a party to that agreement for lease incurs expenditure, that falls foul of this implicit timing requirement, HMRC said. And my response to that, and the response of the upper tribunal, was that when it says where the term to be covered by the lease has begun, that isn't a timing requirement, that's simply saying in circumstances where. Just as with the first word of 61.4. 61.4 says where a lessee incurs capital expenditure. That's obviously not a timing point. The where. Likewise, the where in 61.8. It's simply saying, or the upper tribunal said, in a situation where. So that provided that the term of the lease does begin, in other words, you have got an operating lease, the thing does get going. It doesn't matter when the expenditure is incurred, whether it's while it's still an agreement for a lease or afterwards when the term has begun.
it's probably me, but I just couldn't get there on little a. Can you help me a bit? I just couldn't see how. I can see that where might mean what you say in circumstances where, but it still talks about an agreement for lease where the term to be covered by the lease has begun. I couldn't stretch my head to see how you could read it otherwise.
Well, it's requiring that if you do have an agreement for lease, that it must become a lease. In other words, it's not enough that it's always simply an agreement that never blossoms into a lease. You have to have a lease, but it's not a timing requirement in the sense that it's not requiring the expenditure to be incurred when it's a lease. It's enough that it's an agreement for a lease.
Yes, but my lady's point is about the words "has become." But
because one's looking back in my submission at a time when someone is claiming allowances.
well, I was about to say, is your argument that "has become" means at the moment of entitlement to the allowance?
Yes. Sorry, I was going to say that, and yes. I should
Okay.
say that.
Okay.
Can I explore it one moment? So suppose, forget our case for a moment. Suppose you have an agreement for a lease under which there is an absolutely explicit covenant by the intended tenant to incur some expenditure. And the tenant does that, and then the lease comes into being. Obviously, in your case, that's perfectly good enough because the expenditure is incurred pursuant to a term of the lease, and the lease has come into being.
Yeah.
Supposing that you were wrong about that,
Yeah.
where would the tenant be left? I mean, he's incurred the expenditure pursuant to the terms of the agreement for a lease. Going back to our earlier discussion, it's to be assumed it's capital expenditure, I suppose.
Yeah.
Can the tenant in any way, I mean, is it just lost money?
Just lost money. He's just done it. He didn't realise that requirement was there, I suppose, more for him. I mean, HMRC's response is, well, this is legislation on which you take advice. I'm not sure what advice I would have given, but I'm not sure that's an answer to the question, whether the legislation is being so random, as it were, as insisting upon the incurring of the expenditure after the term of the lease has begun. There is another point to make, which is that there is legislation, and I'll see if I can find it, in Part 2, which says that if you enter into an unconditional obligation to incur expenditure, you're treated as incurring it at that point. So that if the lessee, or the would-be lessee, promises the lessor under the agreement for lease that he will spend the money, and this obviously you won't expect as being a condition of the lessor actually agreeing to carry on and the lease being entered into. So it would be surprising if it was already in the lease having begun. So the lessee promises, and to make that good, contracts with somebody to spend the money. Then he would have incurred that expenditure, even if he spends the money later. But HMRC would say, well, I'm sorry, that's not good enough. You have to wait until the term of the lease starts and then enter into the contract to spend the money, because that's what the legislation requires. And my submission is, no, it doesn't. It's not a chronological requirement in 61.8. It's to do with saying, well, as long as the lease has begun, looking back from the time when the lessee wants to claim allowances. And just one other point. If you go back to 61.1a, that talks about the capital expenditure incurred by the lessor. It's common ground that that isn't imposing any sort of timing requirement. HMRC said, well, the explanation is this is the past tense of incurred, so that it's a lessor who is now a lessor and looking back at when he incurred it. Because it's an important point, because usually someone isn't going to be incurring the expenditure as a lessor after the lease has begun. They would have incurred the expenditure to buy it and then enter into the lease, perhaps. Or at least they might enter into a leasing agreement if they're a finance lessor, but the term of the lease won't start. Well, my submission is there's no 61.8 shouldn't be regarded as some sort of straitjacket that means that under 61(1)(a), the lessor has to incur it when the lease has already started. That wouldn't make sense. And if that's right, there's no reason to read 61(4) in that odd way either, in my submission. Well, those are my submissions. I don't know whether, given that I said I would take all day and I haven't, we could all go off and celebrate. And it's not the longest day we thought it would be, although it is the longest day. Or whether you'd like to hear Mr. Gibbon straight away, but in any event, those are my submissions.
Thank you very much indeed, Mr. Prosser. Yes, and I think we'd like to hear Mr. Gibbon now. We might not. You may still get your reward by us not going right up to the wire, but off we go.
Grateful, my lord. As the Lordship, as the Court is aware, the principal arguments before this Court are essentially a rerun of the arguments before the Upper Tribunal. But that said, the principal focus of my submissions, in particular orally, will be the Section 78 point, so the point on which my client was successful below. I will cover the other points as well. And in essence, does Section 78(1) of the 1990 Act deem Inmarsat to own the satellites upon its succession to IMSO's trade on the 15th of April 1999 for the purposes of capital allowances? So that's the essential point, which can be expressed briefly. I propose to take my submissions in this order, which essentially follows my skeleton argument. First, some very brief points about capital allowances legislation generally, but I'll keep those very brief. Secondly, something on deeming provisions, albeit I recognise that it's essentially agreed ground, that there are a few points in that I would like to draw to the Court's particular attention. Thirdly, I will deal with the Section 78(1) appeal and tack on to that issue 3C, which is in a sort of limbo. As you may remember, this is the tailpiece point, to use the lingo used below. And I say it's in a limbo because the Upper Tribunal said they didn't need to decide it, but the FTT decided it in my client's favour. I've then, with due trepidation, got a brief set of submissions on the purpose of Section 61(4), followed by issue 2, then issue 3A, then issue 3B. So that's the shape I hope to follow, obviously subject to intervention on important points. On the general observations about the allowances legislation, a few very, very obvious points perhaps, but we're here because under classical income tax theory, to use a phrase that was used in a Guthrie case, depreciation wasn't allowed. It wasn't allowed because it was a capital item. And it would be easy to think of capital allowances as the equivalent of depreciation, but they're very different for the purposes of detailed arguments of the sort that this Court is hearing. The allowances in recognisably modern form, if you like, come in with 1945 as initial allowances, as my friend drew your attention to, specifically to encourage industry rebuilding after the war, I think it was said in some of the cases. But it's important to remember that it's never been the case that all capital expenditure leads to capital allowances. Parliament has made choices down the years. I needn't turn it up, but in Guthrie, for instance, they list the categories, the 5 categories as they then were in the 1945 Income Tax Act, that attracted allowances. So there is no general entitlement, and where entitlement is granted, Parliament sets the limits to that entitlement. There's also a difference, to, which I perhaps should highlight briefly, that capital allowances have to be claimed, so the taxpayer may choose whether or not to claim his allowances. By contrast, accounts prepared commercial purposes must show a true and fair view. And broadly speaking, the accountant's view is that depreciation is necessary as part of presenting accounts to show a true and fair view. Hence, as the court will be well aware, that when one gets to tax accounts being filed, one's got to strip out depreciation and then add in, as appropriate, capital allowances. Now, why do I say all that? There's a phrase, and I perhaps don't need to turn this up, but I'll give you the reference, in the Ben Odico case, which is tab 19 of Authorities 1, and it's internal page 1101C, where Lord Hailsham, who was part of the majority, said, to qualify for an allowance, the taxpayer must bring himself within the conditions set by the benevolence of Parliament. Now, benevolence, in a sense, has wider connotations than I need at this point, but what he was seeking to say is that the job of the court is to work out where Parliament's drawn the line, and that line may at times seem arbitrary. Parliament might have chosen to do something different, but sometimes it chose not to. And at positions of difficulty, which inevitably arise in complex legislation, especially with so many facets, as you've seen from my friend's commissions, ultimately one sometimes comes to the position of saying, well, that is where Parliament has chosen to draw the line. So we do so, and this is the last of my points on the capital allowances legislation, one needs to proceed cautiously when the question is asked rhetorically, whether by myself or my learned friend, why would or wouldn't Parliament have done a particular thing? Because the byways, or let's call it the less frequently encountered parts of the legislation, one may not necessarily have had a Parliament which turned its consideration specifically to whether or not something which it might or might not foresee should be taken into account. So the legislation is about legislative choices as to what income release should be made available at what rates in respect of capital expenditure. So moving from that to deeming provisions, we took this very briefly in our skeleton for the obvious reason that it wasn't essentially controversial. I'm not, you'll be pleased to hear, going to be trying to produce a detailed taxonomy of deeming provisions in all their many and glorious forms. The language used in legislation tends, as my friend has already drawn your attention to, nowadays to be along the lines of is to be treated as, regarded as, and certainly there's no suggestion that whether or not you use deemed as opposed to one of those formulations is to make any difference to your approach to things, subject obviously to the general caveat that one's got to look very carefully at what the limit to the deeming is intended by the words chosen. So to that extent, it's simply another facet of statutory interpretation, as this court is extremely used to seeing on a daily basis. From the brief review of authorities that I'm going to cover, which is far short of the full spectrum, I'm going to seek to draw out three particular points. First, that when one talks about deeming, one talks about treating as real the consequences and incidents inevitably flowing. You'll see that from one or two things that I will touch on. Secondly, deeming is frequently found within a mechanism, and the fact that something may be necessary for the purposes of that mechanism doesn't make it necessarily relevant for any wider purpose. And thirdly, related to those two other aspects, there's a theme found in the cases which can be called the principle.
Sorry, what was the third point?
A theme found in some of the cases which can be called the principle of reality, and it's related to the first two. And finally, this isn't about deeming so much, but there is a distinction to be drawn, but I suspect it's not one that's something I need to elaborate now, between assumptions and deeming. And certainly when one comes to section 78, I will in due course be saying that the more apt way to describe what that section does is make assumptions in certain respects. But we'll come to that in due course. Of the authorities, well, you've seen this. I'll just give you the reference. Conscious not to take up more time than necessary. You'll have seen the reference to Marshall and Carr in the upper tribunal's decision. That was paragraph 42 for your note. No disagreement about that between the parties. You'll also have seen the citation of the Schomer case, which was the intention of a deeming provision in laying down a hypothesis is that the hypothesis shall be carried as far as necessary to achieve the legislative objective, but no further. Now, it's really springboarding on that second point. I wanted to take the court to the Hoare case, which is an Authorities Bundle 2 at tab 31. If anybody else like me is struggling to try and do this electronically, it's 368 within the Authorities Bundle. So the facts, I think I can take fairly briefly. This was a rating case. It's about the rating of two national trust properties, Castle Drogo and Petworth, and the proper application of the rating hypothesis. I'll just read out what that was for you. It was by that stage found in the 1988 Local Government Finance Act. And the intention was to find the rent at which it's estimated the hereditament might reasonably be expected to be let from year to year if the tenant undertook to pay all usual rents, rates and taxes, and to bear the costs of repairs and insurance and other expenses necessary to maintain the hereditament in a state to command that rent. So, hypothetical landlord, hypothetical tenant, hypothetical rent. And it was held very unusually that there was only one hypothetical tenant, namely the actual owner, the National Trust. And there was a question whether or not the National Trust's actual funds, its actual own funding position, was relevant to the application of the test, and the National Trust's own appetite to rent such properties. And within the decision, I'd like to show you on 383. Just a very brief passage sidebarred there, if that's the right word. This is Lord Justice Sheeman. The statutory hypothesis is only a mechanism for enabling one to arrive at a value for a particular hereditament for rating purposes. It doesn't entitle the value to depart from the real world further than the hypothesis compels. And then in Lord Justice Peter Gibson's judgment, which is 389 bundle numbering, again there's a sidelined passage. In particular, I would emphasise the necessity to adhere to reality subject only to giving full effect to the statutory hypothesis, so that the hypothetical lessor and lessee act as a prudent lessor and lessee. I would call this the principle of reality, which to my mind is of fundamental importance in this case. And then going on to 388.
Back to 388.
I apologise. Sorry, the trouble is the numbers in the bundle are actually very similar to the numbers in the case itself.
Yes.
I hadn't anticipated that when I was reading through my notes. So back to bundle 388, internal 386.
Yes.
And here we haven't got Tressett in the bundle, but if you see halfway down Lord Justice Peter Gibson's passage there, as was said by Lord Justice Lawton and Tressett, it's important that the statutory world of make-believe should be kept as near as possible to reality. No assumption of any kind should be made unless provided for by statute or decided cases. I suspect I refer to that principally because the phrasing is memorable. But then there's the much better known case of Gray, which is also in the bundle.
So, what do you want us to go to that, or are you
well,
content with what Lord
I
Justice
can do it sufficiently, I suspect, just from this quotation here.
Whichever you'd rather.
Actually, I will need to go to it. So let's go to divider 33.
Yep.
Which starts at 416. I don't think I need to explain the facts anything more than this was an early version of what's now IHT, was inheritance tax, which was at issue. And the passage that was quoted by Lord Justice Peter Gibson is found at internal... Yes, it's internal 372, which is bundle 428. I might just ask you to cast your eye across that rather than me read it out.
Yes.
I'm told that the transcript has been having difficulty picking up my voice. I hope the court has been able to hear me. I've moved the microphone so the transcript...
I'm sorry, yes, I haven't had any difficulty, but obviously the party's interests, at least who are paying for it, to have a...
Exactly, so I've moved the microphone. I hope that...
Well, I'm sure the transcriber will let you know if there's a problem.
That will now help. Thank you. One other short passage I wanted to show you, because it's the useful springboard into the Crossman case, which my friend mentioned. Go back to bundle page 427. 427, so the previous page.
Yeah, I see, yes.
So in the last paragraph at H, halfway through it, certain things are necessarily entailed by the statutory hypothesis. Property must be assumed to have been capable of sale in the open market, even if in fact it was inherently unassignable or held subject to restrictions on sale. The question is what a purchaser in the open market would have paid to enjoy whatever rights attached to the property at the relevant date. See Crossman. Now, pausing there, we say that that's the true principle in Crossman, which I'll show you shortly, which is that in order to be able to make that sale hypothesis work, you have to envision a situation where the very property goes to somebody else. There has to be something which is sold, rather than, for instance, an entitlement might or might not lead to a sale. So for that purpose, therefore, you have to ignore things which make something inherently unassignable, or ignore restrictions which might or might not interfere. But having done so, for the purpose of identifying what is purchased by the purchaser in the hypothesis, you ensure that the purchaser has the very thing which you're trying to value, not some cut-down version of it. And that will be the very thing with all its benefits, but also subject to all the restrictions. So the restrictions are only disapplied for the purpose of ensuring the statutory hypothesis works. So the Crossman case you'll find at tab 23 in the first one.
I sort of made a mental note to stop after you've done the authorities, but how many more authorities are you going to take us to?
I was going to deal only with Crossman and Lionel because my friend had made a particular reference to them this morning. Maybe he didn't.
Okay, well, let's deal with that. Yep, Crossman.
So Crossman's tab 23 in Authorities 1. Now, in many ways, this is one of the most common situations where statutory valuation provisions, statutory hypotheses arise for discussion. It's a case concerning death duty, which was introduced by the Finance Act 1894. And the legislation which you see on page 219 was drafted fairly short form, but gradually case law accrued, really explaining the nature of the hypotheses that need to be made in order to reach a valuation. The facts concerned two deceased shareholders in a Whitechapel brewer called Mann, Crossman and Paulin, where there were rigid restrictions on alienation. And if you were interested in them, and some of them are quite antiquated, they're found at pages 32 to 36 internally.
We might enjoy them over a cup of tea, but unless
Well, yes.
you need to take us to them,
I don't.
Okay.
But they were very.
They are quite surprising.
They are surprising.
Quite surprising.
My lady, you have my point.
Yes, I do.
The passage relied on by my friend is internal page number 72, which is 265. And what Lord Roche says, and it's beguilingly straightforward sounding, is that on an actual sale there must be an actual passing of property. This is towards the end of the sideline passage. And upon a notional sale there must be a notional passing of property. But we say this is a classic mechanism case, if I can call it that. What he was criticising was an approach which took account of the restrictions, because in his view that would not amount to a sale. So as Lord Hailsham put it, and I won't take you to his particular passage, the choice was, before the court, was to assume a sale in the open market of the shares, or else to limit the property to be valued to that which could be sold in the open market. And what he's saying is, no, we're required to value the shares, not simply what is saleable. That's what the legislation tells us to do. And this is a hypothesis, and if you go on to the next page at the bottom, bundle 266, for valuation. And it's the sideline passage. I'm going to ask you to read it through. There is no ongoing purpose to the deeming beyond that. So, for instance, the hypothetical purchaser for the valuation process is irrelevant to the real-world fact that a particular beneficiary, subject to the restrictions which the court's aware of, will have inherited. So, to talk about the sale inevitably leading to a purchase by the purchaser, as my friend did in general terms today, we say ignores the context here. Yes, what Lord Roche said is what he meant, but he meant it in the context of this particular mechanism. And essentially the same point goes for Lionel, which I can take therefore very briefly. What happened in Lionel, which is tab 37, is that there was an argument basically about what information should be available to a purchaser on a hypothetical sale, and should it include confidential information in particular. But when it got to the House of Lords, the taxpayers' representatives also decided they would have a go at saying that Crossman was wrongly decided, which was the first opportunity they had, obviously, because below that Crossman was binding. And so when Lord Reed says in this case, which my friend refers to, that he agrees with Lord Roche, and this is found at 495 in the bundle numbering, sale means a transaction which passes the property. Again, all he is confirming is the position I've already identified in relation to Crossman. I was also originally thinking of referring you to Polydor, but I don't think that assists. It wasn't relied on by the upper tribunal. It was quoted to them, indeed it was quoted to the First-tier Tribunal. But the Polydor case, the essential thrust of it was that inevitably shouldn't be softened to probably. I don't think I need add further this report with further authority on that point. So if that's a
instance, as such, you had no difficulty, or at any rate, no insuperable difficulty getting in. And of course, tomorrow ought to be easier for some people anyway.
Yes, I should say, behind me are some people who've battled in, I'm sure behind my learned friend as well. Others are watching online,
yes,
and are at some distance.
Yes.
So, well, if questions were to crop up on which their instructions were needed, it might be rather hard to get those instructions. And my friend might be in the same position. If it ever came to that, we might need to have a discussion.
Yeah, I suppose just the back of my mind was whether anyone will be assisted by having a slightly later start time, but it doesn't sound as if anybody would be. So, and I'm not actually sure I particularly want to offer it, but I just wanted to know if that was a problem.
I think certainly from a friend's point of view and mine, we're not aware of any video. I think both of us would prefer to start, subject to the court, at the usual time.
We'll say 10:30.